Whawhata lava, Mr. Speaker.
Kevin Haig.
Thank you very much, sir. I want to begin by thanking members of the Select Committee. As others have said, the Health Select Committee works in a very collaborative way, and I appreciate that from members of all sides. I also want to pay tribute to the officials who work with us. This is a fiendishly complex piece of legislation, and the officials did a great job of staying on top of that work. Thank you to the submitters also, who no doubt are watching this debate tonight. Some great submissions were heard by the committee. And thanks in tonight's debate to Annette King and to Simon O'Connor for noting my particular contribution to the debate in the Select Committee, and to Jonathan Coleman, in fact, for agreeing to the changes that I recommended. As others have noted, this bill has two parts, and both of those parts go to the limitation of individual liberty. Part one limits individual liberty for the sake of the public good, and therefore seeks to strike the balance on that issue. And part two deals with another situation of restraint of individual liberty, which is where the state intervenes to curtail the liberty of an individual to take action that would cause harm to themselves. So two of the kinds of situation that this House grapples with from time to time. Picking up from one of Scott Simpson's comments in that most recent contribution, part one, as he said, seeks to amend the Health Act of 1956. And I'm reminded that a couple of years ago in this House we passed the Marriage Equality Act, which was overhauling a piece of legislation from 1955. And that legislation had fossilised in law some attitudes and mores from our society at that time. I've worked with Nikki Kay, in fact, to draft a bill to completely overhaul adoption law, because the Adoption Act, 1955, fossilises some mores and attitudes about children that pertain to that time but are no longer relevant in ours. In 1956, the Health Act was written to deal with some particular issues, chiefly tuberculosis, in fact, and applied attitudes towards the restraint of liberty that prevailed at that time but no longer seem as relevant. Perhaps unusually in this House, I have some experience of applying the 1956 Health Act. I used to be the Executive Director of the New Zealand AIDS Foundation. I dealt with a situation, in fact a couple of situations, in a New Zealand city of a person who had HIV, who persisted, despite all efforts to change his behaviour, to have unsafe sex with multiple sexual partners. And I was faced with the dilemma of what on earth I should do about that. Because doing nothing would mean that a number of people would be needlessly exposed to the risk of HIV infection, something I certainly didn't want on my conscience. So I looked to the law. What did the law allow me to do? What did the Privacy Act permit me to do? What did the Health Act permit me to do? And I was astonished that essentially the only path that the Health Act made available was for me to notify the Medical Officer of Health, who then would seek a court order to detain this man indefinitely. That was the only option that the law provided. So, Mr. Speaker, I am relieved. I played an active part in some of the work that went into drafting the Public Health Bill, which sits at number 30 on the order paper. Would be great to move that forward sometime. specifically to actually provide medical officers of health with a wider suite of tools, with the option of action that was proportionate to the risk that they were trying to mitigate. So I'm very pleased to see these measures progress through the House. I did have some concerns that I expressed in the first reading debate, and members of the Select Committee will know that I raised them repeatedly during our hearings, about whether or not the existence in the bill of the provision that would enable medical officers of health to obtain identifying information about those who had tested positive, for example, for HIV, whether or not that would constitute a disincentive for people to test. Body Positive shared that concern. We heard the Human Rights Commission also expressing some concern about that point, about whether the contact tracing provisions would also provide a disincentive to test. At the AIDS Foundation, we provided our own testing services. Why did we do that, sir? We did that because we knew that many of those who were at risk feared going to established health services for testing, because even though those services were offered anonymously, they didn't trust those services to keep their information anonymous. They feared discrimination, sir. And so I'm still troubled by that risk, whether the benefit of better epidemiological data outweighs the risk that some people will no longer present for testing. But I'm reassured by the evidence of the New Zealand AIDS Foundation and other epidemiologists that my fears are groundless on that point. I want to just briefly note my approval that we are adding chlamydia into the list of conditions for which the powers and provisions of this bill can be used by medical officers of health, because this is our number one sexually transmitted infection. It's the number one infection that we need to be taking action on. So very pleased to see that development. I come to part two, Mr. Speaker, the part of the bill concerned with sunbeds. And as the minority report in the Select Committee's report says, I am, like my Labor colleagues, and I'm sure that Barbara Stewart will mention this in her contribution still to come, I'm disappointed that the government didn't move on this. We've heard, for example, the evidence of what Australia's doing. We've heard the evidence that we repeatedly heard from the cancer organisations, from the health experts. In fact, I think almost all of the evidence that the Select Committee heard on part two said this does not go far enough. There is no benefit to these sunbeds, except in the rare cases that Lewis has mentioned. They should be banned altogether. There is no safe level of exposure. And Mr. Speaker, I think it was Scott Simpson, actually, who at one point in the Select Committee, perhaps after we had just heard the submission, the excellent submission from Consumer New Zealand, who said, you know, there are still people associated with the sunbed industry who maintain that there is no link between their industry and cancer. The very next submission we heard, Mr. Speaker, was the one submission that we heard from someone who said that we oughtn't to totally ban these sunbeds. Someone from the industry who actually presented us with a couple of reports that she printed off the internet that in fact claimed that there was no risk between sunbeds and cancer. And what that goes to, Mr. Speaker, is exactly what Consumer New Zealand had told us, that the industry simply cannot be trusted to act in a responsible way. They've had a voluntary code for a long period of time, and as Annette King has outlined tonight, the industry has repeatedly and in a prolonged way completely failed to comply with its own voluntary code. And in that time, Mr. Speaker, many New Zealanders have been exposed to unnecessary cancer risk. These sunbeds should be banned altogether, and I encourage the House to have the courage to do so.